This video is just one part of Defense Attorney Jim Yeargin's comprehensive video series. Be sure to view other videos for more information. An individual may be placed on probation instead of serving jail time. When you are placed on probation, you must adhere to certain conditions and requirements. If you fail to do so, you may have your probation revoked and be sent back to jail. When your probation is revoked, your probation officer may issue a warrant for your arrest, or he may schedule a probation revocation hearing before a judge. Your probation officer has a great deal of discretion and power in deciding whether to issue a warrant for your arrest or simply scheduling a hearing before a judge. Someone can violate their probation in a handful of ways, either through a technical violation or by violating a special condition. A technical violation is when someone violates a basic rule of probation, such as a failure to report or failure to pay. The maximum punishment for a technical violation is 2 years. This means you could spend up to 2 years in jail if you have that much time left on probation. Violating a special condition means violating a rule of probation the court highlighted and made special because your case requires it. Special condition violations may include failure to complete DUI school, community service, drug and alcohol counseling, or failing a drug screen. The maximum punishment for violating a special condition of probation is having the remainder of your time on probation revoked, no matter how long, and serving that time in jail. Your probation may also be violated if you are arrested on new charges. The arrest is enough to violate your probation, even if the new charges are later dropped or you are found not guilty. Even if you are not arrested but are merely cited for a violation like speeding, this is enough to violate your probation, even if the ticket is later dismissed. If you are arrested on a probation warrant, you do not have the right to a bond, and most judges will not give you a bond on a probation warrant. You can expect to sit in jail for days, weeks, or even months, waiting to see a judge regarding the probation violation. Hiring an attorney can get you seen by a judge and released much faster than waiting in jail. At the probation revocation hearing, the state merely has to prove you violated your probation by a preponderance of the evidence, not beyond a reasonable doubt. Preponderance of the evidence is a much lower burden of proof. The state only has to prove the elements necessary to establish that you violated your probation. They do not have to prove any of the facts from your original case. The state will be represented either by a prosecutor or your probation officer. The probation revocation hearing is determined by a judge, and you do not have the right to a trial by jury. If the judge determines you violated your probation, you may face increased jail time, fines, community service, counseling, or other conditions. A probation revocation is not necessary in every case. Many times, an attorney can negotiate a settlement to reinstate your probation so you do not have to go back to jail or face increased fines and conditions. As with any criminal offense, you may have several defenses available to you. Hiring an attorney will demonstrate to the court that you are taking the alleged violation seriously and may help you avoid jail time and increased fines and conditions. To learn how we can help you fight your probation revocation, contact us today.